Hi, everybody. First off, I want to thank Patty and Maria for all the work that they did on this conference today. It's been a great endeavor. They worked so hard on it. And so I really want to thank them. Oh, there's Maria back there, and Patty's still out in the hallway working it. I also want to thank Jackie Connell because she was the brain in this presentation. I'm just the mouse. Okay, so she did a lot of that. Jackie's our vice president. I'm the director of operations at the Family Trust. Dalton is the, okay, there we go. Thank you. So I just wanted to start off with telling you a little bit about what the Achieva Family Trust is. I think some of you already know that based upon everything that you've heard today. We help secure financial futures for people with disabilities. We do a lot more than that, but overall, that was what we're attempting to do. The Family Trust was established in 1998, primarily by some people in the room, in response to the Social Security Administration's legislation in 1993 that allowed the creation of a pooled trust. We are what's called a corporate trustee for 3 types of special needs trusts, which will be talked about later. And it's to provide access to financial funds for a wide range of individuals and that have disabilities and their families as well. We do no-cost consultations, and we provide resources for individuals and families to assist with these future planning needs. We currently have over, I think it's 2,700 beneficiaries now, and we're in 19 states in addition to Pennsylvania. And we actually just heard yesterday that we're over $300 million in assets. So I say that to tell you, we know what we're doing. Considerations for planning. When you have someone in your life that's receiving benefits, and your planning goals should be attempting to preserve those benefits and yet still utilize family wealth, the money received through settlement or even through earnings. What benefits are we talking about? The ones that Matt talked about earlier: SSI, SSDI, Medicaid, Medicare, any of those benefits that for some people are life-saving benefits or life-changing benefits. So we have needs-based benefits, which Matt talked about, and entitlements. So I think we know now that the needs-based are supplemental, Medicaid, and waiver. Those are ones that you didn't have to put anything into the system. The entitlement benefits, I used to tell my clients, I used to be an attorney, I used to tell my clients, these are the ones you purchased. Every time you made a paycheck, they took a little bit out, that was your premium payment. So that's SSDI. The survivor benefits was you saving for your survivors, and Medicare. Supplemental security income, as we said, needs-based with the $943 a month. The asset limit there, which I must say hasn't changed in 50 years, is $2,000. And as Matt pointed out, it's linked to Medicaid. If you're on SSI in Pennsylvania, you're automatically a Medicaid recipient. Medicaid is, again, the needs-based with the same asset limit, unless it's waiver, and then the asset limit is slightly higher, but $8,000 is still not a lot. I always use the example, $2,000 is an asset limit. If your car breaks down on your way home from here, you're probably going to need more than $2,000. So what are the future planning tools? I think this addresses the first thing I want to point out, that these family members that we're here talking to you about, we have a personal planning guide, which is available on our website. That's not just about finances. It's a very involved packet that you literally can go through. You can do it digitally or by paper. There's a link on our website, and literally you can talk about all the different things that you can kind of take a person-centered approach to it. This is what my loved one likes to do. This is what he doesn't like to do. These are the things he likes to spend money on, doesn't like to spend money on, to really, so that you're not in the position that Joe was in, where, he's in Europe and finds out he might not know all those details. If Joe's mother and father had prepared a future planning guide, then maybe Joe would have had a little bit more of a heads up as to what he needed to do. That also includes in there where you're categorizing some of your financial things that are in place. You can have, I used to tell this to my clients, when you give somebody, don't just have a will, you want to have bank account numbers. You want to have the information they need to do that. I would have clients walk into my office with a shoebox and dump it on the table. They had no idea. They had a will, but they didn't know where the accounts were. Is there a safe deposit box? Where's the title to the house? All of those kind of things, the deed to the house. So all of those kind of things can be very pertinent. The other thing you're going to have for a future planning tool are the legal documents. And lastly, another good tool now in this day and age are able accounts. The legal documents, a will, last will and testament is something that makes the determination of where the money goes. If you have a will, you're going to need to be sure, if you have someone in your life with special needs, that that will has a clause in there that creates a special needs trust for those people. Simply having the will is not enough. You've got to have something in that document that's indicating it's creating that. You can also have what's called an independent special needs trust. I know some people that do that. They have a will, and then the will pours into an already created special needs trust. These can be first party, meaning they were established by the beneficiary themselves. Third party, mean mom and dad, grandma, grandpa, whoever it is, establishes the trust. And then the pooled trust, which we'll talk about in a minute. The other legal documents would be what Nora talked about, the guardianship orders, if necessary, powers of attorney, and medical directive. So those are all kind of legal documents that are going to be necessary in a future planning program. So what are future planning goals? Avoiding disqualification, I think, is one of the most important to everybody in this room that is worried about people with special needs. We can't leave assets directly to a disabled individual. Otherwise, we could disqualify them from receiving those government benefits. And that could also lead to unnecessary penalties. Additionally, we don't want anybody who's on benefits to lose benefits. If that person is on SSI, assistance, waiver, those income and asset levels, they're looked at. And if they look at that and the people are over, then they could actually lose those benefits. I work with an elderly woman who, she's actually a friend of mine. I kind of look in on her. She went over the $2,000 limit by $87 at the beginning of the year, and they stopped her Social Security, her SSI benefits. She survives on age benefits of $400 a month and her SSI of $500, and they took it away from her. She didn't know what was going on. So I'm up there. I'm an attorney who's practiced in this area, and I had a hard time navigating the system. So we always want to protect those benefits so we don't ever have to get into that situation or those conversations where that kind of thing happens. Options to protect those benefits, as we said, the third-party trust, the first-party trust, and also the ABLE accounts. With a special needs trust, you're protecting those benefits, the means-tested government benefits, because of those low limits, and even a small settlement. If someone's in a car accident and they have a $10,000 settlement, and that settlement check is deposited into their bank account, that could throw them over. So we're also looking at that. A lot of people say, well, I don't have any assets. I don't have any assets. My child doesn't have any assets. But you don't know about future assets that might be out there. A special needs trust provides oversight and management. Sometimes it's not just about the benefits. You might have somebody who's not on benefits. A trustee can have discretion on the distributions, and it can avoid court intervention because generally, if you have those things set up beforehand, you don't need to go to a court. Maybe for the guardianship, you have a trustee that's handling all those financial matters for the person. With those trusts, there's no cash disbursements to the beneficiary directly. In other words, we call these spendthrift trusts. We make it impossible for the person to spend their money or to jeopardize assets by using the trust. And also, there's nonprofit trust companies like the Achieva Family Trust that administer trusts that are smaller in size. What I'm hearing lately from banks, they're not going to touch a third-party trust under $1 million. Doesn't affect a lot of people. At the Achieva Family Trust and other nonprofits that do the pooled trust, it could be as low as $500. And that, as I said with my friend, she was over by $87. We couldn't have helped her because she was elderly. But the point being is that even if someone has $1,000 that's going to kick them out of benefit, you can use trusts in order to somehow protect that. So the one thing that we say about these is that the trust funds are used to supplement any extra care and above and beyond what the government provides. So supplement means it can be used for supplemental items such as clothing, vacation, medical needs that aren't paid for by Medicaid, transportation, recreation, entertainment. Supplant, they cannot be used for housing, utilities, and cash access. This slide up until September 30th also said food. Food is now off the table and they're not counting those. But in other words, the money in the trust can't be used to those, or it could negate the trust itself. Home purchases and accessibility renovations may also be considered from payment out of a special needs trust. So developing the future plan, what are some of the things we're trying to avoid? A direct inheritance. In the situation that I believe Joe was alluding to when he spoke during the family discussion, he was saying that his brother inherited money. So now brother inherits money. What are we going to do about this? We can establish a first-party trust so that brother can keep the money that he got through the direct inheritance and not have to do it. Now, if mom and dad had done a third-party trust, they could have then said where the other money goes later, instead of Medicaid having to be paid back from those funds. The other thing that you're trying to avoid is disinheritance. It breaks my heart when I look at wills that were drafted, prior to the establishment of the Pooled Trust Act that said, I'm not leaving anything to my child because they're receiving government benefits. I've seen those wills. I've probated them. I had a friend of mine that had it herself. The woman had 4 daughters. I know she didn't want to disinherit that daughter. She wanted to leave her the same thing. She always treated those 4 girls equally. So why would you have to disinherit? You can use a trust to make sure you don't have to disinherit. The other thing about the disinheritance that I say too is that, you always have family politics at play. People say, okay, I have 4 kids. I'm going to leave all the money to 3, but the other 3 are going to take care of the other sister. Okay. Well, yeah, you trust your 3 daughters. You love your 3 daughters. You don't know necessarily who they're going to marry and what kind of unscrupulousness they might bring to the play. So I always say that rather than disinheriting and expecting those other children to pick it up, just do the trust in the first place and try to take care of it. Asset transfers. Subject to 36 to 60-month look-back period, the disabled beneficiary may not be eligible to receive benefits for 5 years up to the transfer. Transfers to certain supplemental needs trusts, however, may be exempt from the look-back and may not cause that same period of ineligibility. So what's the myth? I have to be rich to establish a special needs trust. As I said earlier, that's false. Some corporate trustees, such as banks, this says I have 500,000 in here, but like I said, I'm hearing lately it's more like $1 million. You can start with a minimum. And the fact is, the implementation of a proper estate plan that includes a family member with a disability should involve an attorney who's knowledgeable about drafting these special needs trusts and government benefits. For the same reason why you wouldn't go to a brain surgeon to operate on your heart, you don't want to go to a criminal attorney to draft a special needs trust. You're going to want to work with someone who's an expert in this field. Again, so the documents, how do I create it? Either the last will and testament or the standalone trust document. Regardless of which document, a knowledgeable estate planning attorney should assist you with drafting and executing a special needs trust. I've had attorneys who, like I said, the criminal attorney tries to draft a special needs trust for himself. Doesn't matter. Just because you have that law degree doesn't mean you can do this. Look for the experts in this field. The last will and testament, it says where your assets are going to go upon your death. It should never be a do-it-yourself endeavor. I really, it's not just because I'm an attorney. I really say stay away from those will kits that you see online. The same thing that Nora said, it might not be specific to Pennsylvania. It may be that you're looking at just some general document. Oh, I only paid $100 for it. Oh, well, it's only totally invalid. So you want to make sure, spend the money on talking to a knowledgeable attorney, or, look for pro bono services like the legal clinic at Pitt, or we talked about we're having that legal clinic at Family Trust, something like that. Now, if you die without making a will, your assets are going to be distributed to your heirs in accordance with the applicable intestacy law, meaning, your spouse and your kids, it goes down the line, nieces, nephews, siblings first before that. This could make your family member ineligible because you weren't able to create the trust. It's going to go to them directly. Special needs trust. Okay, what types? The third party, which is the common law, and that can be, then there can also be a paid back, and there can also be a pooled. Who's the trustee? All special needs trusts are going to have a trustee, either corporate or an individual. You can have more than one trustee, except for a pooled trust. With a pooled trust, it's with an entity. The Achieva Family Trust has a pooled trust. They are the trustee for those pooled trusts. Exemptions, resources in a trust are not considered available and therefore don't count for those eligibility standards. This allows individuals to have more than $2,000 in the bank in case their car breaks down, or the $8,000 waiver limit. Third-party trust. This would be family and friends of the individual with a disability. Create the trust to benefit the individual with a disability while still preserving eligibility for supports and services such as Medicaid, waiver, and SSI. Family and friends can fund that third-party trust either during their lifetime, so you could start it tomorrow and put money in it, or it could be your will says it'll fund the trust at the time of your passing. These can be very flexible, and the remaining funds then can be left to other family members rather than having to pay it back to Medicaid. No payback to state Medicaid agencies, and there's also no age limit on the third party. With the payback, or what we call the first party payback, the trust is funded with assets that belong to the individual with special needs, as in they got either through the inheritance, or I use this example of the settlement. The beneficiary has to be disabled under the United States Code per that section. Also with the payback, they have to be under 65. They can have, again, an individual or corporate trustee, should be drafted by an attorney, and it should be approved by DHS. DHS should sign off on it prior to that taken care, because DHS ultimately, because it's payback, has sort of a stake, so to speak, in it. Once DHS's lien is paid, then the remaining funds can be designated. Any amounts remaining after state payback are given to those specified charities, family, friends. Now, alternatively, say you have, I don't know, $10,000, that example I used. Are you going to want to use a payback trust if the person is on waiver? Probably not, because Medicaid is probably going to be owed a whole lot more in a lien than $10,000. So there's the option of the pooled trust, and that's what we're going to talk about in a little bit. When you are choosing a trustee for any type of special needs trust, the things to consider are the trustee's relationship to the beneficiary, the time organization required to administer a trust, and the know-how about disability benefits. Very often people say, well, I'm going to leave my son in charge of the third-party special needs trust for my other son. While that is totally plausible, I wouldn't do that unless that person is very well versed in the administration of trust. There's a lot of requirements. You don't want to do anything that's going to jeopardize government benefit. And also there's the relationship to think about. You have two sons. You leave half of it to one son, half to the other son who's in a special needs trust. And you appoint the son who gets everything in the end as the administrator, or as the trustee of that trust. That trustee sort of has an interest in how much money is being spent on his sibling, correct? Because whatever he doesn't spend comes to him and his heirs in the long run, okay? While most families, I don't think, would operate like that, it's always a risk. And again, I always try to say to people, you're not just talking at that point about the kids that you raised, you're talking about the kids you raised married, that can have influence over those kind of things. They're not necessarily the decision makers, but I don't need to tell anybody here that you've seen married couples where one was very influenced by the other and maybe did things that normally were out of character for that person, just as a matter of keeping marital bliss and peace. So always remember that when you're thinking about that. There are the options of co-trustees. Co-trustees can make something a little bit more complicated, but you're always going to want to have successor trustees. So if you are naming that one son as a trustee, you want to make sure that you're naming, okay, who's his successor? Where does it go after that? What happens a lot of times, I think what you see with these trustees, and Jackie could probably say this as well, they do leave it to the son as the trustee and say that the special needs person, say it's a mental health issue, and they start calling their brother, the trustee, every 15 minutes because they need something. It can put stress on that relationship. And I always say, your special needs child still needs a brother and he needs a trustee. So why not take some of that pressure off and look for someone independent to sort of function in that financial realm? And that way his sibling is able to still be his brother and not have to be the one that says, no, you can't have money for this, you can't have money for that. Yeah, it can be a difficult situation between the families. Beneficiary designations. One thing that I always do when my clients would come in, we would draft the will, we would draft a trust, and then they would tell me, I did the legal clinic a few years ago for Achieva when I was still an attorney, and one of the things that people came in, they had not changed any of their beneficiary designations. So the IRAs still said it paid out to the son. It didn't say it paid out to the trust or whatever the situation is, IRA, 401k, bank accounts, whatever they are. So unless you've designated in that trust, or excuse me, unless you've designated in the beneficiary designation of anything, you might still be in the same problem, even though you created all the appropriate documents. Always, always, always look at the beneficiary designations to make sure they match the estate plan. Okay, so the pooled trust. That was the option that I was talking about. That what happens is a parent, a grandparent, a legal guardian, or a court can establish the pooled trust. The beneficiary, again, has to be disabled, should be under 65. It's established and maintained by a nonprofit organization. Achieva Family Trust operates a pooled trust. In this case, it's established by a joinder agreement usually, which is a standard format that's been approved by Social Security. It's been approved by DHS. And so it's a lot simpler. You don't need to hire an attorney to create this kind of trust. You fill out the joinder agreement, you execute the joinder agreement, and the funds are all pulled together. Now everybody has their own account. So if I put 1,000 in and you put 10,000 in, I have 1,000 to spend, you have 10,000 to spend. But it's pooled for investment purposes. All the money's in there and we pool it. At the beneficiary's death, the money doesn't go back to Medicaid because, well, at AFT, we struck a deal. We said, leave the money here and we'll spend it on other people with disabilities. Some of you may have heard about our charitable residual grant. Last year, we gave away over $2 million. We're on track to give away $2 million this year. Those are with pooled trust funds that remained with Achieva Family Trust, with the caveat that we're spending that money on other people with disabilities. ABLE. So looking at the ABLE Act, Achieving a Better Life Experience, the ABLE Act was actually signed into law by President Obama on December 19th, 2014. It created this new provision under 529 of the IRS code. 529A was the IRS code about saving for education. 529B is what this is, and it's allowing you to save for a special needs individual with a disability for qualified disability-related expenses. The ABLE Savings Program is administered by the PA Treasury Department and can be contacted at paable.gov or the phone number that I have listed there. In Pennsylvania, there's one agency, can't remember what the name of the is it Fifth Third Bank, Jackie? Fifth Third Bank administers all of the ABLE savings accounts. So, but what you do is you go through the state. So you're going to contact PA ABLE program to set one up. Qualified disability expenses. These include education, housing, transportation, employment training and supports, assistive technology, health and wellness, legal and administrative fees, funeral and burial costs, and basic housing and living expenses. Okay? A little bit different than what you saw the language with the trust. So the ABLE, you have a little bit more leeway. SSA is not deeming payments out of an ABLE account as in-kind support and maintenance. An account owner can pay for shelter costs out of ABLE without getting the SSI reduction, unlike with the special needs trust. Now, the beneficiary themselves is the account owner, but authorized signers can be added to the account. What I like about this, about the ABLE account, is that it does provide an individual with a disability a little bit of autonomy because they can have a card, they're using it themselves. The woman who talked about the credit card earlier today and about establishing credit, this isn't establishing credit, but it is a way about giving somebody a little bit more autonomy over their own person. And currently, the beneficiary had to be disabled or had an onset of the disability before age 26. In 2026, it goes up to 46. That was legislation which either 1 or 2 years ago, but this is changing for it to go up to the age of 46. So the disability would have had to have occurred prior to age 46. Now, there is a limit. Contributions in order to be qualified have to be under $18,000 a year for 2024. In previous years, it was $17,000. So those always kind of tend to go up, similar to the gifting laws, the federal gifting laws that, it was $15,000, $16,000. It's going up. So it's $18,000 for 2024. If they're working, they can add another $14,580 above the 18 each year. So you can see the incentive here for people that are working to use these ABLE accounts to facilitate that work and not lose their government benefits. SSI recipients, they can save up to $100,000 without SSI being affected. If you're over the $100,000, your SSI benefits would be suspended until the account drops below that amount. Medical benefits are going to continue though. So even though you'll lose your SSI, you're probably going to be able to keep your medical benefits. And then with an ABLE account, remainder funds can be transferred to a disabled sibling or a beneficiary's estate, if there is an estate there. So I had set this time aside for any questions. I kind of tried to give you a brief overview, but trying to sum up some of the things that are available. But what I can say in my overview of this, the most important thing is to make a plan, whether it's an ABLE account, whether it's a special needs trust, whatever it is, do that. I practiced law for 30 years, and I always use the example that, people don't like to talk about this stuff. We don't like to talk about when we are gone. We don't like to talk about the negative parts of the future, aging, all those things are difficult. But I never had anybody come into my office and execute those documents and walk out the door and drop dead. Let's put it that way, okay? But 99.9% of the people that came into my office and executed the documents went like this. I'm so relieved. I have this taken care of. So don't let the negative aspects of planning stop you, because I'm going to tell you right now, I've seen it with my own eyes. The positive effects far outweigh that. Knowing that something has been established, that there is a plan, is integral, especially when you have a special needs person in your life that you're trying to protect. So, are there any questions? Oh, I'm sorry, you're right there.
What's available for the person? What is available for the person who is over 65?
Well, you can, over 65, you can do it, but the look back is probably going to impact it, and you're going to have probably a waiting period before you can actually start to utilize the funds. Does that make sense? Okay. Jack, you want to pitch in? I'm not making this clear. Yeah, she said, what can we do for somebody over 65? And I said, well, you could create the trust. Well, the third-party trust you can always create. You can do that over 65. But with the first-party trusts, they might be able to create the trust, but then not touch the money for about 5 years till the look-back period is over. Because what they've done is they're shifting that money out of their name, so it's no longer in their name, but there's a 5-year waiting period of look back. So say they're 66, you establish the trust is there, they cannot use the trust funds until, what was the number? Are you 6671?
Yeah, and I mean, that's for a pooled trust. You can't even establish a payback trust for someone over 65, so that's not even an option. And I think sort of the struggle to answer the question is because there isn't really a good option. If someone is over 65 and they do receive funds directly, so in other words, a third-party trust wasn't set up, there are not a lot of options. I mean, the main option is you just have to spend it down until you're back under resource, you don't have benefits. So that's obviously a big issue for a lot of people. If you've ever gone through the experience of getting on SSI or Medicaid, it can sometimes take years. They don't make it easy. So, I mean, that's really the worst case scenario. We don't want someone to have to forfeit benefits for a period of time until they're back under resource. So that's really why, in terms of future planning, we really encourage do a third party trust. You don't want to leave it to chance that your loved one comes into money after reaching age 65 because the government just doesn't make it easy. Because let's face it, as everyone ages, disability becomes much more likely. So if we were all able to shelter our resources into our elder years, the government would be paying a lot of Medicaid out and getting not a lot back. So again, they put that 65 age limit for that reason. There's a presumption that as we all age, disability will become likely. So definitely, don't leave to chance and hope that a first party trust will work, because you just don't know how old your loved one will be when you pass.
And even with the 5-year look back period, the older we get, 5 years gets longer. So like, even if you do choose to do one of those methods, say it's at 71. Okay, well, now you're looking at the 5 years are going to be over when I'm 76. It's probably not a good option. The better option is to make the plan ahead of time to do that.
So if my daughter thinks right now, like she thinks, then we create a trust when she's 65, does that trust disappear?
No, because you're talking about a third party trust. The third party trust is not, that's why we're saying do the third party planning. If she's 85 when she inherits that money, the third party trust will still be in place. We're only talking about the first party trust has that 65 limit on it. So that's why we're saying write the trust now, third party trust, leaving it to her special needs trust, so that not that she inherits it, that the trust inherits it whenever you pass, and then she'll be protected. I'm sorry, this man over here.
Can you have more than one trust? Say, for example, there's a sibling and you're not certain that the sibling is going to do a good job. So can you have a third-party trust and maybe a pool trust? Is that doable, or is that not allowed under law?
No, you can have as many trusts as you want.
I know cost is involved.
Right. The pooled trust, obviously, you're not incurring the same legal fees that you will, and you're establishing that at the time. These third-party trusts are more pending. They're waiting for something to happen in the future, although they could pay into the pool with that too. But I would say that if you're not certain about that, one of the benefits is to go with a corporate trustee, because then it's professionals that handle the money. You know that there's investment policy with how the money is invested, how it's spent, following the regulations of the government, not to disrupt benefits, all of that. Go ahead, Chris.
Is there a limit on the amount in an ABLE account if you have SSDI?
I think it's only for SSI that it's 18,000.
So is there a limit on the amount in an ABLE account if you have SSDI?
Included the 100,000,
Or they don't say.
right?
The 100,000.
So the 100,000 overall limit in terms of how much you can save in an Enable account does not apply if you're on SSD. It only applies to SSI. So you can save, much, much more than that and be on SSD, Medicaid, Medicare, and have no impact. It's just the SSI that you can only save up to 100,000 and maintain the benefit. In terms of the 18,000 annually, that applies to all benefits. Yeah, that's just the max you can save per year for Able.
Right.
With a pooled trust, can it be established with a small amount of money and then get future deposits?
Yes. Well, that one was easy. We have some questions over here in this.
Hello.
Hello.
Thank you. My question not exactly about the trust. Just wonder if the trust is established, like special need trust, and the corporate is a trustee, they manage. But if the person is living in residential living or in a group home, and who is his voice? Like who knew the needs to request the money from the trust?
Oh, well, it could be the facility that they live in. We go when we have the trustees, they could tell us that somebody needs something. The fund request can be made by anyone that, he's living with that's there. It's then reviewed by our trust administrators to make sure that it's a qualified amount that we can spend money on. So the person can either make the beneficiary request themselves or someone can do it on their behalf.
So it can be person who is, not legally mentioned in any documents like power of attorney. So it can be just person who is in that facility or even relatives. Yeah.
Well, if it's a group home situation, there's been some kind of relationship established through that agency that can do that. Service coordination can ask on that person's behalf. As I said, the person can ask on their own behalf. Family member, brother or sister. Yes. Go ahead, Chrissy. Yes. So here, hold on a minute. I can't hear you online.
Hi there. There's a couple of the trust administrators here, and we all have some group homes on our caseload. So I know with the ones that I manage, there's one contact person there that oversees all of the individuals in their program that have a special needs trust fund, and all my requests come from that one person. I don't like to take them from multiple people, but sometimes we do take them from managers of the group homes, whoever. But
Supervisors.
yeah, but I usually have a point of contact there.
And the other thing is too, if we got a fund request, I'll leave this to the TAs as well. If we got a request that we were suspect of, it would be investigated. So if we got it from someone, a fund request from someone we've never heard of, we're like, who is this person? It would be investigated to make sure that it was legitimate to the best of our ability.
What question? The refers to the real quickly like this line, right?
How quickly will it happen?
Children now can buy the best proof about how to.
With our bills, we have a lot of the bills, like you mentioned, cell phone or utilities or anything like that. We do that on a method where they're just paid monthly automatically. We could do a fund request that just says when the bill comes in, we pay it. If it's something different, like a vacation, once it's sent in, it'll be reviewed and approved. Just so you know, we make disbursements 3 to 4 times a week. Like if they need something from Amazon, we do the Amazon order, it goes through. I don't want to give you a specific time to say it's always going to be within one day. It's probably not going to happen. Jackie is looking for the mic.
Well, not the one.
Okay.
You're not so about it's related to that. She called me.
Take them through it.
And hi, yes, my name's Diane. I'm a trust administrator, and
Achieva Family Trust has a 10 to 14 business day processing time. I'm happy to say that we perform much quicker than that. We do have 3 check runs. There are time limitations. So if you need something out the door from Achieva on a Wednesday, it needs to be reviewed from the trust administrator, go up through our supervision line. Once it gets final approval and sent down to finance, it has to be down to finance by like 11 a.m. on a Monday to have a check ready for Wednesday. Now, there are certain emergency situations that arise all the time. My car broke down or somebody stranded. We can, with Jackie's approval, with our supervisor Jeff's approval, get a check in hand maybe within 24 hours. So it's kind of case dependent, depending on what the need is and how fast we can move, and if we can go ahead and approve it.
And wouldn't you add to, Diane, that it's depending on what the request is for? If it's something a little bit, like if it's something that it's obvious that it's needed, the car breaks down, it's going to be assessed to see whether it's actually needed.
That you just call it a little bit like phone break. How do we get a phone or what do we like the account things like?
Right. So we have 3 business accounts that we deal directly with: Best Buy, Apple, Amazon. And so if a phone breaks, we can, go through our business account and get it much quicker than maybe trying to get funds out to a family member to go ahead and purchase it. And a lot of a huge benefit of that is nobody really has to leave their home. We can do that for you. So if it's something quickly that we can get on Amazon, in the rain, snow, 90-degree weather, nobody has to go out shopping for it. We can go ahead and do that through our business account, send it directly to them. The bill is then sent to the trust administrator that we will then, settle up with the trust and have their trust pay for that back to the business account. So it's very streamlined. We all do it, multiple times, a day sometimes. So that's a huge benefit that Achieva offers as well, is working directly with our, business accounts to get the needs met for the beneficiary. And as far as like daily bills, your phone bill, your cable bill, like Leanne said, you can have that sent directly to the trust, care of Achieva Family Trust, and it's called a standing order. And once that standing order is established, it allows the trust administrator to pay that bill every time that bill comes across their desk and sent out the door. So that speeds up things too. A lot of times if somebody wants a bill paid, they get their bill at their house, then they have to mail it to Achieva or, some other form. And it really does, take a little longer to get that process, where if we just streamline it and have it come directly to the trust, we can pay it quickly and efficiently and avoid any kind of late charges.
And the other thing I would add to that too is like with insurances for a house, insurances for a car, we're tracking all that. So whereas the person, if we weren't tracking it, 3 days after the policy expired, we might be getting a notice, oh, my insurance just expired. Whereas we take that in and we're tracking those as long as we know about it. We track them and then we're kind of staying ahead of it that way as well.
Yeah, right. So I guess in just in terms of getting things out the door, once we get that final approval, it can go pretty quickly.
I think there were some questions over on this side. Thanks, Diane.
This is sort of related to the same issue. If there's a third party corporate trust in place with a trust protector, does that change anything if the person moves into a residential facility?
Jackie, I don't.
So that person can still protect that trust, or there could be 1 or 2 or 3 people. We were advised at one point to not have 2 people, to have 3. We wanted to have 2 in case one passed away. What happens if the person who is controlling it passes away?
Yeah. I think with the trust protectors too, sometimes when you have 2 people of equal weight, then you run into these disputes.
Right. So they said have 3. If
right.
you have
an odd number.
Have 3.
Have an odd number.
So if there's only 1 and that person passes away, what happens if that person is the protector?
And the document itself doesn't give you
Do you put a second person in there, like just in case? Can you specify?
I think that would depend on the legal document that created it, because not every trust has a trust protector. So whoever established that trust created the trust protector in there. So I think you'd have to defer to the language, and a lot of that would probably be interpretation.
I mean, if we named a family member.
Oh.
Is what I'm saying.
Are you the guardian?
Yes.
Then I believe that you could name a second. Again, I got to defer to the document if it said that
Okay.
who had the power to name a secondary, or let's have Jackie answer.
I gotta pay.
I can get you one. I mean, because I'm probably the person that told her not to put two people on something, I'm just going to address that real quickly. I mean, I think that the issue is, when you name two trust protectors or two trustees or three all together, they all have to come to some level of agreement on what's going on. So sometimes naming multiples is not a great idea, depending on who you're naming. I mean, sometimes you won't get along. However, you should name successors. So if you're naming, your sibling is number one, and then you're worried about that person passing, now you're going to put your niece. And if it's not your niece, it's somebody else. So, I mean, I think, having multiples can be problematic for decision-making purposes. Successors is always a good idea. So
I've even drafted them where the trust protector could appoint their own successor. I'm not a big fan of that. I'd rather have it all set up like what Jackie just said. But some people say that, like, well, the next generation is only 18. We don't know who's going to be the responsible person in the family, so they're like, can we just say that when I'm ready to let go, I'm going to let someone else do it?
Yeah. And I mean, I definitely recommend if you are drafting with a lawyer to talk about these things because, a lot of times the documents aren't flexible enough that if there is a vacant role that you can just easily put someone in it. Sometimes you have to go to court. Sometimes there's a lot of legal work to be done. So, certainly name as many successors as you can. Also give your successors the ability to appoint successors. Maybe it's not clear today who that person is, but in 20 years, that might be a little bit more obvious. So give yourself and your document as much flexibility as you can to address things that change over time so that you're not in your law office every year making changes to the document.
Because ultimately that document needs to be clear so that the document is going to be what rules. And if it's not clear, then it's going to be a judge that rules. There were some hands up over here. This lady in the front row and right over here too. Oh, and that gentleman over there.
Oh, hi. Getting back to the third party trust for a person who's 60, is Achieva going to manage that for me, or can they not?
If you name Achieva as the trustee, that's what we do. We are a corporate trustee. So you would have to draft the trust that said, and the trustee is whoever it is that you choose to do that. But yes, Achieva can do that.
Okay.
Well, actually, the Achieva Family Trust does that.
And manage it.
Correct. We manage all the funds. We manage the disbursements. We manage the investment. We have investment advisors that do that, all of that.
Okay, even though it's not a pooled trust.
No, the third party trust is still handled, that there's investment advisors that handle all the investments. The trust administrators that we're just speaking over here, they handle the third party trust the same as the pool.
Okay, thank you.
This lady back here had one, and the gentleman down there.
Is the Achieva Family Trust an appropriate place to come for guidance concerning guardianship and establishment of trusts? In a family where we have grandparents with a will but no trusts, we have a widowed mom with no will yet, and of 3 grandchildren, 2 of the 3 have intellectual disabilities, and we do not want to leave the third one with an unmanageable situation. So do we need to see a lawyer first? Do we come to the trust for recommendations of where to go?
Yeah, we will talk to you about what a trust does, how it works, all of those things. We have a list of attorneys that do this special needs planning. So a lot of times it runs that way, that you come and talk to us first and we say, okay, now you need the documents drafted. Here's the list to go talk to these people. Sometimes you can go directly in, or you might want to interview us to see if you want us to be the trustee. And then you go to your attorney and you say, I've already decided on Achieva Family Trust. It kind of goes both ways. Sometimes it may be the lawyer would not recommend, but provide the same way we do. a list of people that handle special needs trusts, but it could go either way. But I'd always tell you, you could come and talk to us.
You could come to us first for guidance as to
Yeah.
what you can do here or what you can refer.
Generally can answer. Yeah, we'll answer generally the questions. I can't give legal advice,
I get it. I
but
get
we
it.
can.
Yeah, we have a lot of family business and start somewhere.
Yeah.
So I understand this is not a tax seminar, but so funding of a third-party trust, parents pass away to a child. Today we see a large part of a parent's asset base could be IRAs, and is there things like I'll just ask a real simple question. Like, does it make sense to look at like a Roth conversion strategy before you die so that these assets pass from the trust to the children with the least tax consequences? And that's the kind of question I'm getting at here.
No, and I recognize that, and Achieva Family Trust on the whole recognized that several years back, that people hold a lot of their assets. We used to require complete liquidation before, and you would just invest it as cash with us. We now have an IRA policy, or I guess it's a retirement benefits policy. I shouldn't just limit it to IRA, where recognizing the tax consequences, you don't want to liquidate an IRA in 5 minutes and then have it just dissipated on taxes.
Right.
So yes, we have an IRA policy now where there's certain other prescriptions. There's a certain amount of cash you have to also be coming in with that, but where we will accept in certain situations retirement assets.
Okay.
And I think I'll just add to that. I mean, prior to the passing of the Secure Act, which is like a relatively new law around this, I think most people tried to shift their IRAs to the non-disabled beneficiary in their trust. There's actually some benefits to now actually having the IRA pay directly into the trust, because you can avail yourself to a longer stretch, a lifetime stretch for the disabled individual, whereas your non-disabled children would have to liquidate over 10 years. So we're actually seeing a bit of a shift where people were kind of getting away from leaving retirement assets to trust, and now it's actually becoming more popular again. So if you're thinking about, leaving an inherited IRA directly to a third-party trust, talk to the lawyer that you have drafting your docs and just make sure that it meets the Secure Act requirements. And again, we can avail that to the lifetime stretch instead of the 10-year.
Do you have those requirements? I understand.
I do generally. I mean, I can talk with you a little bit about it offline, because we're seeing that more and more in the documents that we have. So,
Okay.
Yep.
And then back to your slides. As I understood it, the special needs trust could be used to purchase or renovate a home,
Again,
but not actually pay for rent.
depending on the asset that you're on. But with the SSI, because you are allowed to own a home, when you're on SSI, you're allowed one home. You can't have multiple homes, but you can have one home. So it depends on, again, there's certain situations where we will accept real estate as an asset of the trust, that they could purchase it, or we've done other scenarios. What I would say is it's a case-by-case basis. Is that fair enough to say?
yeah, and I mean, I would say that there's a difference between the trust purchasing a house or owning a house, or the trust paying your mortgage or paying your rent. So the trust can actually buy the house, again, under certain circumstances. Every trustee has kind of rules around real estate, but the individual can own a home, or the trust can own a home, or the trust can buy a home for the individual without issue, but not pay a monthly mortgage or not pay a monthly rent if someone's on SSI without issue. So again, it kind of depends on the benefits, and it depends on what you're asking the trustee to do. We do pay rent. We do pay mortgages. We don't want to if you're on SSI. Your SSI will get limited on some level if we do, but there are circumstances where we still do it, where the trust is well funded, but we try to avoid it because of the SSI rules.
Okay. Thank you.
And that's the other thing that I think that's important about what we keep saying about the future plan. There, as you can see, there's just a lot of questions that could come up. So it's better to get ahead of these questions rather than we're in a when I used to do it more elderly planning, and we used to call it crisis planning, because one spouse is 10 minutes away from being put into a nursing home and the other one wants to remain in the community. And now we're trying to plan. Well, if you had come to me 5 years ago, we could have established trust. We could have prohibited the crisis planning, because nobody should be making big decisions under crisis unless you have to. So the point being is, with the future planning, collect all that information and start finding out what's going on. The other benefit that I think sometimes with going with the corporate is tax law changes, inheritance law changes. The guardianship law changed just this year. So when you're with entities that are more versed in, the legal aspects of things, it can be better, because we're keeping up on it, because it's our day-to-day job. We have to know it. As an individual, I mean, if you were to try to keep up with it the same way, I probably couldn't keep up with what you do every day at your job. There's more of an expertise that comes with that. Does anybody else have anything? Chris has somebody, I guess, over on online. We'll send you from one end of the room to the other.
Yep.
I can agree. Once a person with a disability or guardian establishes a pooled trust, can anyone contribute money to that trust, or must it always be the person with the disability?
Anyone can contribute to the pool trust.
Their name, yeah.
Yeah. I mean, again, there are disadvantages to putting third-party money into a pool trust. If you're going to significantly, as a family member, want to give money to the individual with a disability, you should use the third-party trust, because of, obviously, you can protect remainder funds. But yeah, I mean, we have beneficiaries who have family members who put small amounts in the pool trust all the time just to give some extra spending money. That's not a problem.
Anything else? We have a question back here.
I'm not sure if it was mentioned, but if I understand correctly, the trust can be written in such a way that allows the trustee to make a contribution to an ABLE account. And by virtue of that, doesn't it allow funds to be spent per the rules under ABLE when the rules of the trust may not allow for that, correct?
We do sometimes make a fund request where we transfer from the trust to the ABLE account, yes.
And I'm also just going to throw it out there because I have some more familiarity. I've had people ask me if Social Security benefits can pay directly to an ABLE account, and that's a dangerous place to be. So I don't think the administration even allows it, but it hits a bank account and then you can make a contribution as long as it's under the limit.
This is the way that I look at it with Social Security. It is meant to be what it says it is. It's supplemental security income. They want to see that if they're giving you money to meet your rent and to meet your, well, it used to be food. I'm dating myself a little bit here, but to make your rent, those household expenses, they want to see that it's going for that. And if it can go into those other accounts, I think it could get murky and it can get mucky. And it's probably better to just have things separate so that there's no confusion about what's being spent on what and how.
And I think that it's also important to understand that there can be one person that is the rep payee for Social Security, another person who's acting as the trustee on a supplemental needs trust, and potentially a third person who's a responsible party or authorized signer on an ABLE account, because you can have all of that and have different people handling it accordingly.
Absolutely. In fact, unless you, like Achieva's policy, we don't serve as rep payee because we're the trustee. But if you are in an Achieva group home, if you're in an Achieva community living situation, they're the only people that our rep payee department handles. So, yeah, there generally is. There can also be, it really does take a village and take a team to get all of that together. It's just trying to simplify it with what's the least amount of friction that we can create, and just making sure that everybody's on the same page. That's probably one of the most important things.
And I just want to add a personal plug. If Achieva Family Trust ever gets to the point where you're willing to consider letting families maintain their personal financial advisors to invest the assets, let me know.
Thank you.